All right, Professor Waller Code Week 2 here for your business law 4 to 6 minute video chapter summary 16. Yes, and here we go. So the beginning was talking about the statute of frauds. So this is where every state has a statute that stipulates what type of contracts must be in writing. So that is what is referred to as the statute of fraud. So it has to be in writing. Origins of the statute right below it is where parties to a contract were not allowed to testify if a dispute arose which led to different types of practices, and then those practices from there on led to what was passed in 1677 by the English Parliament, which was known as an Act for the Prevention of Frauds and Prejudices, because the practice that they were doing beforehand had too many problems and they needed to enact something that would resolve that. So that is where state legislation comes in, and it says, although each state has a statute modeled after the English Act, statutes vary slightly from state to state. So all states require certain types of writing in contracts, but for the actual name, like, it doesn't apply if the statute of frauds is involved. So they've referred to that as misleading, but it does not apply to the fraud itself. And then, so this is where the interest in land comes in with the contracts. So calling for the sale of land is not enforceable unless it is in writing or evidenced by a written memorandum. And they say land is real property. So you can't take that away. And an example could be someone, say, selling their property to someone else, but then that person decides later on they don't want to sell their property. And by rule, the person they were selling it to could not enforce the contract. So for collateral promises, this is a secondary promise to a principal transaction or primary contractual relationship. So essentially it's a promise that is made by a third party to assume debts, obligations, regulations of the primary party. And for this, really, and for anything business-wise, it's all about performance. So a primary obligation is not conditioned on the person's failure to perform, whereas a secondary obligation is where a third party fails to pay when the primary is in debt. If that makes sense, that's what the difference is between primary and secondary. But the main purpose rule, as I read about, was an exception. So an oral promise to answer for the debt covered by statute of frauds was the main purpose, and they used that as an exception when it came to primary and secondary obligations. So that leads to the promises made in consideration of marriage, which is a promise to make a monetary payment or property in consideration of a promise to marry. And that is where a prenup comes in. And my example is, for prenup, is I knew this NFL player who his family made the wife sign the contract of a prenup, even though they've been together since early high school years, that since he was making all that money now, like, she wouldn't be able to divorce him and then take all of it. And that was the problem with, say, Jeff Bezos, where his wife is the richest woman in the world now because they didn't sign a prenup. So that's my example there. And then the contract for sale goods and partial performances can be included. So when it comes to sufficiency of writing, a written contract will satisfy the writing requirement as well as the written memorandum, or an electronic record of evidences that the agreement is signed. So you might ask, what constitutes a writing? And the answer is that it can consist of any confirmation, invoice, sales slip, check, fax, or even email. The written contract need not to consist of a single document in order to constitute an enforceable contract. So a memorandum or note evidencing an oral contract is needed for a combination of writing and written contracts. So lastly, I'll talk for these last minute and a half. I'll talk about the payroll evidence rule. So this is if a court finds that a written contract represents the complete and final statement of the party's agreement, it will not allow either party to present payroll evidence. So exceptions, though, of that include 7 different things, and I'll list it right here. It's when contracts are subsequently modified, when contracts are voidable or voided, contracts containing ambiguous terms, contracts that are incomplete, contracts that have included prior dealing or trading, contracts orally agreed upon, and then contracts that have any obvious error and whatnot. So then kind of just to put it all into one for the written contracts for payroll, you have four different types where they can be fully integrated ones, not fully integrated ones, uh, payroll evidence that is inadmissible, and payroll evidence that is admissible. So I hope I didn't butcher the parole. I really thought it was spelled with an E on the end. Maybe it's pronounced differently, like parole. But for chapter 16, that's really what it is. Starts with the statute of frauds, goes to the origin, how the state legislation is involved, how land is included, real property of contracts involving that, collateral promises, prenups, main purpose rule, promises made by marriage, which, yeah, prenup for there as well, sufficiency in writing, and the payroll evidence rule. So that is all combined into, let's say, about a 6-minute video. So hope that worked out and hope you have a great weekend.